The court's decision came in response to an application filed by Sherwood Global Outreach, an entity that's seeking an order for the respondent to release a vehicle they had impounded with registration number GN 2925-20 to the applicant. Despite the court's orders, the respondent repeatedly failed to appear before the court, leading to the issuance of the bench warrant. During proceedings on Monday, the lawyer for the applicant, Abraham Arthur, moved an application for the committal of the CID boss and the DG of the Legal and Prosecution Unit for contempt. The court found that the respondent had blatantly refused to honor its directives, prompting the issuance of the arrest warrant. The court had specifically ordered the IGP to order the Director General of the Criminal Investigation Department of the Ghana Police Service, as well as the Director of the Legal and Prosecution of the Ghana Police Service, to appear before the court on Monday morning. And while the orders had been carried out, the two respondents were not in court. According to the court, there was evidence on record to show that the court orders had been carried out and that there was affidavit of service indicating that the order of the court to serve on the IGP had been carried out. Again, the previous order was served on the IGP on March 26th. The presiding judge says the court has extended enough courtesy to these public officers, and due to the fact that there is nobody above the law, he issued a bench warrant for the arrest of the respondents. Reporting from the court complex, my name is Richard Kujenya for Joy News.
So that is the story, which is why that High Court has called for the arrest of these two, the Director General of the CID of the Ghana Police Service and the Director General of the Legal Prosecution Unit of the Ghana Police Service as well. We still have Peter Lanshini Tobu, Superintendent retired, joining the conversation. Welcome back, Supo.
Thank you very much, Robert.
What is your initial reaction to this development? And now the court saying that they had been invited to appear before court on a number of occasions, and they had blatantly refused, for which reason they are being cited for contempt. Your reaction?
Thank you very much. This is just to show that the rule of law is something that all of us should push for it to work. No single individual in this country is above the law. The Inspector General of Police, who happened to be the Chief Executive of the Ghana Police Service, a unitary command. The police service is a unitary command. So if you invite the Inspector General of Police on the matter of criminal investigation, he would direct the Director General of CID to respond. And that is exactly what the IGP did. What I've been told, I've tried to do some cross-check. What I've been told is that when the contempt application was filed, the Director General of CID was not served, and the Director of Legal for the CID was not also served. And they were surprised, hearing it in the news, that the court had issued a bench warrant. Simply put, even if you are a normal citizen, an ordinary citizen of this country, and a bench warrant is issued against you, and you hear it even on air, as a responsible citizen, what I expect of you is that within 24 hours, you put yourself before the court without any police officer coming to look for you. But here's the case. The order has been given that the Director General of CID and the Director Legal for CID should be arrested. I expect them that within 24 hours, nobody is going to arrest them. They should voluntarily, as responsible police officers, walk to the court, present themselves before the court, and let the court appreciate that we didn't get any notice of the application for contempt, even though we have been here. But whatever it is that you fail to appear before the court on 2 or 3 occasions as stated by the judge, you go in there and try to explain yourself. And whatever it is, there will be a position by the judge. But I expect the Director General of CID and the Director Legal of the CID to appear before the court as soon as. Nobody should go looking for them.
But this positioning or this attitude where sometimes people are meant to appear before the courts, they are summoned and they refuse to appear. Some of them, we've had ministers do that, on a number of occasions and all of that. What signal does that send? Because in this instance, they've also been told that there have been attempts to retrieve that vehicle owned by Sherwood Global Outreach to no avail.
The truth is that we have 3 arms of government. the police belong to the executive arm of government. And the government chief legal officer, the attorney general, will definitely always be giving them guidance. The judiciary is another arm of government, in another organ of state. And these checks and balances is enough to ensure that our democracy makes progress. So if you are invited to appear before a court of competent jurisdiction, irrespective of who you are, as a member of the executive, you are supposed to appear. If you don't appear, the judge is going to do what the law says he should do. And that is exactly what the judge has done. And I'm expecting the police, the Director General of the Criminal Investigations Department, and the Director of the Legal Division of the CID to immediately, as a matter of agency, respecting the Inspector General of Police, that he has directed you to comply with what the court has directed. You appear before the court immediately and let the court know that you are not unprofessional police officers and that you respect the rule of law, and that as law enforcement officers, you should be the first person to respect the law, because it is an indictment on the whole institution, the Ghana Police Service, and it is an indictment on the person who appointed you as Director General CID, that you don't respect the law. I don't want to believe they will do that, and I'm quite sure that they will be before the court as soon as possible.
Let me also bring in, just hold for me, Supo. Let me bring in Kweku Paintsel, who is also a lawyer, a practitioner of the law. Thank you, Mr. Paintsel, for joining the conversation, sir.
Thank you.
What is your initial reaction to this? I mean, it's not every day that you hear that the Director General of the CID or the Director General of, criminal, prosecution, the Legal Prosecution Unit of the Ghana Police Service is actually being called for by the High Court in terms of an arrest for contempt of court. What is your initial understanding of what has happened?
I think it's in order, and I will say that because every disrespect that is shown to a court of law can invite the sanctions, which includes an order for the person to appear before the court. I mean, and my understanding of what's going on is that the affected people, let me call them the respondents, may have shown some conduct that the court considers disrespectful. I don't know the specific facts, but the impression I'm getting so far is that there was someone, or they were to appear before the court and they failed to do. The whole idea of coming to court is the fact that it is not your pleasure. If for someone to appear before the court, it's not your pleasure. You have to be there, or you must have very good reasons for not appearing before the court, and those reasons must be communicated to the court. If you are not available to appear before the court, then your counsel or your lawyer may then tell the court the specific reason for your inability to come. And typically, the court may take you on by asking you to furnish the court with the evidence of the reason why you didn't come to court. It could be you went to hospital, whatever it is. But the long and short is that if there is a summons for you to appear before a court of law, I'm just citing one because contempt is constituted by various conducts. The bottom line is disrespect for the court. That's the bottom line. But can be constituted by various conducts, and this is only one. So with regard to them, of course, you may not hear every day these things in the news, but then it just shows you that the court has power. The whole idea of contempt is any form of disrespect, disobedience, whatever, that is shown to a court of law. The court has power and authority to punish you as for contempt. But then the punishment can only take place when you are summoned, you appear before the court, the charge is laid, and the court will give you an opportunity to respond to the particular charge or allegation that has been made against you. So even though you don't hear this every day, it just gives you an idea. It just tells you that there are lots of powers that the court has got over everybody in the country, literally everybody in the country, and that it makes them the courts. That is to say, the third estate of the nation. So, I mean, what's going on, even though it doesn't happen every day, I would say I'm not surprised in the least. It just gives you an idea that there are powers that the court has got over everybody that people may not know. Maybe that's what is making the news. So
in respect of the summons of the court, it would appear that the two gentlemen were not in the know, and that at some point they may even have heard of it for the first time in the news or on social media and the rest. How does the court react in these incidents, especially if the people have not directly or personally been served, or if there is proof that they were not in the know? What then happens?
Well, what is happening now is that what the court has issued is a summons or an order for their arrest to be brought before the court. And the reason why they have to be brought before the court is for the charge of contempt or whatever allegation for which using the court made order for it to be laid formally. And if indeed it is their case that they were unaware of court proceedings and so forth and so on, that will form part of their defense or will form their defense before the court. And please, I'd like you to appreciate that these orders are not regularly made. And therefore, for them even to claim that they were not aware, I'm not sure our judges issue such orders just for the sake of it. I am certain, even though I've not seen, based on the way our courts conduct business, that the judge may have some form of evidence before it to form a prima facie case. In other words, to form a case sufficiently strong for the judge to make the order that he made, which would be that evidence possibly of a bailiff having served certain processes, maybe hearing notices on them to appear on a specific day and so forth and so on. And that is, because this, with due respect, are not light orders that court make. Court make these orders based on serious evidence. But of course, since Ghanaians are what we are, if they come and they can demonstrate to the court the specific allegation that is made against them, if they can make a case that it is not so, the court is constituted by human beings like you and I, even though they are judges. They will look at the evidence, and it is the evidence that will come before the court that will form the basis of any defense that they may have. And obviously, if the judge reviews the evidence, for instance, comes to the conclusion, as you're saying, that maybe they were not aware, why not? A judge is a judge, and he will do what he has to do. In other words, he will discharge them. But maybe, for all that they are saying, there will be evidence before the court that will be incriminating sufficiently strong enough to form a basis for the allegation that they were aware of the proceedings and failed to attend the court. And if they did, maybe to be a better defense for them to say, maybe whatever they will be able to say, maybe there was a clash, maybe they were on their way, maybe whatever. But there will have to be a valid defense before the court. But please, let me also make this point that sometimes I notice that our judges, once in a while, because the kind of thing that is happening is a very regular feature of how things happen in our courts. Most of these uniformed policemen, even especially soldiers, they don't even think that there are laws in this country that affect them, and therefore they treat the court with slight. So whenever you hear of a judge having made the order, I can assure you that the kind of evidence that the judge has got to make that kind of order will be sufficiently strong enough. But I'll put it this way. The judge is still not obliged. At the end of the day, still not compelled to commit the person to a term of prison. It could be cautioned and so forth and so on. But whenever you hear of such an order, it demonstrates the judge's anger, if I may put it that way, in quotes. The judge's frustration, the judge's whatever of the conduct of the police, in this case, the particular officers
right.
whose names have been mentioned.
Right.
It just demonstrates. I can tell you that a judge who makes that order, it doesn't make it, out of slight. He does it based on very strong evidence that would warrant making such an order. So that's the way I will look at it, even though I've not seen the evidence. Right.
The judge will definitely not take this lightly. Hold for me,
No.
Kukupen. So let me bring in Peter Lanshini Tobu. Supo, so look at the storyline. Yesterday, counsel for the application, Abraham Arthur, actually pushed for this. The committal of the CID boss and the Director General of Legal and Prosecution, stating specifically that there had been an order for the Inspector General of Police to order the Director General of the CID and the Director General of the Legal and Prosecution unit of the Ghana Police Service to appear before the court, which was yesterday. And that was about the third occasion. Now that the orders had been carried out by the respondents, but they were not in court. And then the Justice of the Court, Lydia Osei Mafo, also goes on to talk about the fact that no one is above the law and that they have to, appear before the court. What then does this do in terms of, and like has been mentioned, the Ghana Police Service is on a part of the executive, and the courts, of course, are part of the judiciary. What does this do in terms of the executive judiciary arrangement or relationship? How can it be made better in this particular instance?
Thank you very much. I will be very surprised that the Director General of CID and the Director General, the Director Legal, will violate a directive from the Inspector General of Police and by extension fail to appear before a court of competent jurisdiction that has demanded that they appear. I will be very surprised. That notwithstanding, even it is very clear also that probably the processes that they were supposed to be served with to enable them appear before court were not served on them in person. Because I know if you are talking about contempt, it's personal. You cannot hold the Ghana Police Service or you cannot hold the Criminal Investigation Department for contempt, but you can hold the Commissioner CID or you can hold the Director General Legal. So if the Commissioner CID was held for contempt, and for that matter, he comes to prove that I wasn't served. I've known on several occasions that somebody comes to the police headquarters and says, I am looking for the chief. And you get into an office and there is a chief in charge of the office and they say, this is the chief. And he says, this is a message from the court. And I want you to sign. And the man signs. And he's actually not the person who's supposed to be served. Before he goes through the process to get to the real person who's supposed to be served, probably takes about a day or two. And if the person was supposed to report to the court on that particular day, of course, the judge will be very angry that the person failed to report. But probably it is just administrative bureaucracies that has resulted in these things. I am saying, if every process was followed...
But Peter Lanchini-Tobu, let me just clarify. You say it could be administrative, bottlenecks that have led to this. It could be. But look at the situation. On March 19, the court held that it was satisfied for the second time. In fact, that was the second time that the notice of application for the two to appear before the court had been brought, and then the IGP was served. Then the third occasion happened. 3 occasions of the court reaching out to the IGP, seeking that the two be directed to appear before the court. I mean, what sort of bottlenecks could, result in this on 3 occasions?
That justifies the anger of the judge. And as my lawyer friend said, look, no judge will give such an order for issue a warrant for you to be arrested if the person hasn't gotten to the elastic limit. So the truth is that let's allow the police to appear and defend themselves and let them appreciate the fact that nobody in this country is above the law. The relationship between the executive and the judiciary and even the legislature is so important that they have to live in a community intertwined, respecting each other's roles and ensuring that checks and balances are well respected by all of us so that this nation built on democratic principles can progress. So let's allow it to slide, and then we wait for them to appear before the court, and we see how the story rolls out.
If it is confirmed that these gentlemen, and I'll go to Kweku Painto on that matter from the legal standpoint, but from the standpoint of the police, if it is confirmed that they were duly served and refused blatantly, as has been used, to appear before the court, are there internal structures for maybe, for example, bringing the name of the police service into disrepute on these matters? How are they handled within the nucleus of the police service?
Yeah, as I started saying, even the violation of the directive from the Inspector General of Police alone is enough for caution, to the point that they even added that you refuse to take instructions from the Inspector General of Police, and you even refuse to go by a court order. Then what kind of police officer are you? Which law governs your activities? Because whatever it is, you can never refuse directive from the Inspector General of Police. And you don't have any legal basis to say when the court directs you will not comply. You cannot. So both ways, you've actually brought the name of the police service into disrepute. That is, if they fail to prove that they were really not in line with all the procedures to enable them appear before court.
Hold for me, Peter Tobu. Coming to you, Kweku Painto, what could be the consequences of these actions? Yes, they are high-ranking police officers, but yes, they also fall under the ambit of the 1992 Constitution. No one is above the law. What could be the consequences from the least to the highest or the worst if it is proven that they intentionally, blatantly refused the orders of the court?
The court will have power. You know, this power of the contempt, power to punish for contempt, is derived from common law, which means that in Ghana we don't have a statute. In other words, we don't have a law made by Parliament on contempt as part of our laws. So it's been derived from the common law, even though there are traces of it in our statutes and whatever. There's no one comprehensive law that prescribes, for instance, punishment and stuff like that. But what our judges have been doing is that they base themselves on the common law principles. And what it means is that when you are guilty of contempt, we say contempt is quasi-criminal. In other words, it's in the nature of a criminal offense. And what it means is
but it is technically not a crime.
It is technically not, but it partakes of the nature of a crime. So we say it's quasi-criminal. And what it means is that I will talk about the experience of punishment for contempt. I have had a client who was jailed 6 months. It was totally unbelievable for contempt in a matrimonial cause. 6 months. It's the power that is reserved to the judges. And a judge can...
But just confirm, did the person serve the sentence? The 6 months?
He served the entire sentence. And if we're interested in the kind of sentence, we've got a sentence which we call the judge has put the key in your pocket, which is typically an order that requires you to reverse a certain state of affairs. In that particular case, my client had been guilty of taking a wife's car. It was the surprising part was a matrimonial cause. Taking a wife's car, going to have an accident with it, failing to repair it and whatever. So the judge sentenced him and said that anytime that he's able to restore the car to the heir, from the very day, the sentence will end. And he could not. So he spent all the 6 months in prison. So I've had that person experience of a client who was jailed 6 months. I'm talking about 6 months for a matrimonial matter. And, of course, it was a disobedience to the court proceedings. Then, of course, at the lower end, the judge can caution and discharge you. So in between these two is everything at the judge's discretion. Judge can sentence you to a fine. He can sentence you to an imprisonment. He can do both, and so forth and so on. And that is the fate of these police officers when they are convicted. But typically, in the nature of state matters and whatever, if the judge even finds them guilty of contempt, I have my read out if the judge will be willing to sentence them to a term of prison. It's very likely to be a caution and a discharge if the judge even finds them guilty. My gut feelings tells me so based on the experience with the handling of our police officers and soldiers and so forth and so on. I wouldn't say they belong to a different category of law, but I can talk of experience about how our judges should normally treat matters of contempt involving the security services. That's my personal view.
Gentlemen, we're so grateful for your time. Kweku Painto is a lawyer, and we also had Superintendent retired.
Can I just
Peter
have 30 minutes, 30 seconds of the time?
30 seconds. Okay, go ahead.
Thank you so much. You know, I will be very surprised even if the Director General of CID appears before court and at the end of the day he's cautioned and discharged. That alone is an indictment. I know.
You will be surprised if he is cautioned and discharged?
I will expect him to be just acquitted and discharged to show that, in fact, she was not wrong. Because he's cautioned and discharged, it means that she actually did something untoward. And at the top of the criminal investigation department, the criminal justice system can be affected if the relationship between the police and the judiciary is not good enough. For the Director General of Police to appear before court and be cautioned and discharged is an indictment on the whole of the Ghana Police Service, and she's likely to lose her appointment. The president can decide to take her out.
But you can't disrespect the court. If the court finds him guilty, how would the court find him guilty? The court will not deliberately leave him or her because he's a policeman. I mean, to say that is an indictment on our legal system itself. He don't be just left free because he's a policeman or whatever. The only way the court can act judicially is to rely on the evidence and, like I said, caution and discharge. A judge cannot throw away the evidence because you're a policeman, you're a soldier. No, the court will never do that.
Okay, so
unless the evidence does not fit.
Gentlemen,
so the hope is that the evidence will be enough for her to be acquitted. And
I wouldn't say so, but I'm saying that on the basis of the assumption that the evidence is laid before the court and the court finds acceptable, the court will do what the law requires the court to do. There's no law that requires a judge to ignore evidence because of somebody's position. No way, it can't be.
Gentlemen, we'll leave the court to take care of the matter. Whether the person will be cautioned and discharged, which would come with some tainting, or acquitted and discharged, we'll leave the court to settle those matters. But Pinto, thank you so much for joining the conversation. He's a lawyer. Superintendent retired Peter Lanchini Tobu is also a former police officer, and he's a member of parliament as well. When we return shortly, we're going to focus on that crucial issue. Now, the PURC has been communicating with the Electricity Company of Ghana on a number of matters, including putting out a load-shedding timetable, at least in some context. Things have come to a head, and now the PURC is calling for jail time for Samuel Dubik Mahama, the boss of the ECG, together with other board members, about 8 of them put together. But we're going to be finding out why exactly push has come to shove. Stay with us. We'll be right back.
Legal and Prosecution of the Ghana